IP attorney. I've been doing this about 10 years, and that's probably 95% of what I do is intellectual property. Our firm deals in patents, trademarks, copyrights, trade secrets, all that stuff. I typically spend most of my time on the litigation side. So, like you heard before, I did give a similar talk to this, to the first rounds. There's more formalities now. We have to go through this whole intro and stuff. I'm sure most everybody hates PowerPoints, but nonetheless, I'll put it up there for purposes of the visual learners who want to be able to see something on the screen and can ignore whatever I say. So, I'm here to focus in on branding and trademarks really, but I do want to give everybody a little bit of an overview because a lot of people sort of mix and match the terms patents, trademarks, copyrights without necessarily knowing which one applies to what, and there is some overlap, so it can be confusing. And so I did want to give you sort of a thumbnail sketch of what each one is. All right, patents, most people are familiar with patents. There are several different types of patents. There are design patents that protect your ornamental design, the appearance of whatever product you have. If you have a product that has a distinctive appearance, it may be something you'd want to try to protect through a design patent. The other main type of patent is a utility patent, and that is the patent that most people think of. The patent on a light bulb, the patent on some wireless router or some device. That's the idea of a utility patent is something that's new, it's functional, and it's not obvious to those that are in the field of endeavor for that particular type of invention. I also have listed down there plant patents, which I suspect nobody really has any interest in, and provisional applications, which is a little bit more interesting, and actually for startups and young businesses, provisionals are actually pretty useful. So a utility patent is the main patent that most people think about. It's expensive and it takes a long time to get. Typically you're talking at least 3 years before you hear the first thing from the patent office when you file your patent application. You can pay more money and get it put on an expedited track. So that is a possibility, and if you have the money to do it, it's a pretty good option. But for a lot of people, coming up with the $6 to $10 grand to file the application in the first place is more than they want to deal with. And so to add another, say, $2,500 surcharge on top of that, that's charged not by me or by a firm, but by the patent office itself to put it on that expedited track. So the idea behind a provisional application is that it basically marks your place in time with the patent office and gives you a year to go out and try to decide whether your invention is worth following through on a full patent process. Okay, so the key for patents is not disclosing whatever your invention is to others. Once you disclose it, you put it in jeopardy, and if it's been out there for more than a year, then you basically have lost the ability to patent your invention. So, so even though, sort of the beginning of a new venture, at the beginning, where you're starting up a business, money's tight. If you have an invention that you think that you're building your business on, that you think that's important to you, this is one of those things that you kind of have to do. If you're building on some technology that's new to the industry, you've got to get something filed on it, because once you start to disclose it, whether that's to people in groups like this, whether that's to venture capitalists, whether that's to banks trying to get loans, trying to get funding, all those can potentially be disclosures that would preclude you from getting the protection later.
Can I ask you something? Even if you have them sign a non-disclosure?
Non-disclosure helps, but it's still. You have two problems. Number one is if you disclose it so widely, even with non-disclosures, that there may be the risk that it gets out. And number two, if somebody else basically tries to take it and use it, you may have a non-disclosure agreement, but you may not know anything about what they've done with it. So, I'm a big proponent of just trying to get something filed before you disclose it at all, if that's possible. And the appeal of the provisional is it's much less expensive. It's sort of a pared down application. You don't have to have certain of the components that you need whenever you file a full utility application. So from dealing with lawyers, whether my firm or any firm, it's going to be cheaper for a provisional application. And on the patent office side, with the fees from the patent office, it is cheaper too. And so I said that a lot of times the patent application costs you $6 or $10 grand to get prepared and filed. Provisional application, depending on the technology, might be, let's say, $2,500 to $3,500. So it saves a lot of money, and it buys you a year. So once you've filed it, you've got your filing date. You can say that your product is, or you can say your product is patent pending. You can disclose it to whomever you want, and you have basically that year to decide whether this invention of yours is valuable enough for you that it's worth going the full utility application. And so for a lot of startups, it's a good option for them. Just some basics on patents. It's 20 years from your earliest filing date. Lots of times people will file an application. They will, you may file multiple applications. It's 20 years from that earliest application you file is how long you get it. The U.S. is now what's called a first inventor to file country. If you and I both invent the same thing and I get to the patent office first, I win, basically. So that's another motivation for getting there as soon as you can. You don't shop around your invention for 6 months. If you have something you think is valuable and you're able to do it, you want to try to do it as soon as you can. And protection is country by country. So you have a great invention and they start selling it across Europe. If you only have U.S. patents, they do you no good for pursuing someone elsewhere. Only if someone is making it here and exporting it elsewhere, or someone else is exporting it, importing it from elsewhere to the U.S., can you do something with the U.S. patent? Yeah.
So if I patent something, I have 20 years to exploit it under my property.
Yes.
What happens after those 20 years? When is this filed?
It's dedicated to the public. That's the bargain that you strike with the government.
Suppose I am the public, where I can access those?
You can go to uspto.gov, the United States Patent and Trademark Office.gov. They have a search engine there. Google Patents has a search engine. Once a patent is expired, you can use what's in that. That information, that invention, is dedicated to the public. So basically, you pay the government for 20 years of exclusivity. In exchange, you give it to the public once it's done. Now, it's possible that it's always possible that someone has filed patents on certain improvements, and so if you go and you think you can use this expired patent and you try to make updates to it or improvements to it that are covered by other patents that are still in existence, you can still run into some trouble. But as a general principle, the patent's expired, you can use the information in there. Yes, ma'am.
I just wanted to verify, so we're talking about like a software program, we're not talking about a hard, it doesn't have to be like something you can touch, it could be like.
For patenting, for what's
Yeah.
eligible for patenting?
Yeah.
Well, you can patent products, you can patent methods of manufacturing, I will say that the state of the law is in flux in terms of software and computer issues, and in fact there was just a Supreme Court decision that came out today that further lessened the likelihood that if you're dealing with sort of a software type invention that you're going to be able to patent it. So on the software side, it's a much more difficult thing to cover on patents. And, given the way that the law is going, it's possible, even if you were able to, two issues. Number one, it's taken far longer to try to get anything related to software patented. And secondly, given the way that the law is going, it's likely that those patent, the law may change sometime in the future to where that patent won't be for a while. But copyrights are an option from a software perspective. So copyrights, another type of IP that you can receive. This protects original works of authorship. So something original to you, you didn't copy it from somebody else. It covers literary works, music, and videos. It does cover computer programs, art, buildings, building plans, blueprints, that sort of thing. It gives you, copyrights give you the exclusive right to make and distribute copies, sell them, publish them, display them. Your copyright actually exists as soon as you create the work. So if you paint a painting, you write the code, your copyright exists from that moment. However, to the extent you want to try to enforce it down the road, you actually have to register it with the Copyright Office. Yes, ma'am.
Does that apply to photos?
Yes. Yes, it applies to photos also. Photos can get tricky if you are a professional photographer and you have lots and lots and lots of pictures. It is usually not practical to register every photo. It is possible to register whole libraries of photos as long as they're all by the same photographer. So if you have a big bulk of photos, you are able to do it sort of in tranches. I can't remember if the limit's 250 at a time or if it's 1,000 at a time, but it is possible to do it if you have big groups of photos. But yes, copyright applies to photos. Yes, sir.
And when you do this, when you're registering it, you put it on a disc or something, all your works, and send it to the Library of Congress or whatever it is.
Right.
And at least it's
Yes,
you're the
right.
one that did it.
You have to have a deposit work which you provide the Library of Congress. There are some exceptions. I think with software, for example, if you have real lengthy code, I think you can give the first and last 25 pages of your code if you have something that's really bulky. But yes, generally speaking, you deposit your work with the Copyright Office as part of the registration
And
process.
just some electronic media, whether it's a drive, a thumb
Right.
drive, or
I think you can put it on CD. I don't know if you can give it to them in other on other types of media, but I'm pretty
Does
sure
it cost to
you can
register?
It does cost to register. The Copyright Office, I can't remember what their fees are now.
It's like 35 per,
Per work, and
and then
then
if you have, it's 110 if you have
there you
for
go.
what, per
a
submission?
group. A group.
Group submission. And then with copyrights, unlike patents where you have to convince an examiner that your invention is worthy of a patent, from copyright purposes, all they do is make sure that you've checked all the right boxes on your registration and that you've done everything right and you receive copyright. That doesn't guarantee that it's valid, but that but basically that gives you have your copyright if you pay them the money. So yes, sir.
So with a copyright, specifically with code, it says protects original works of authorship. What can I use that to be as an advantage over a competitor? Is there anything in copyrights that's really
Well,
an
and
advantage?
it does get tricky with software because really copyright protects you from someone either copying or selling, using, producing a work that's substantially similar to your work. So if somebody else is able to sort of have the same functionality using different code that's not that hasn't been a copy of yours, then that's going to fall outside of the realm of copyright. So in other words, if I write a program that performs some function or task, if someone else comes up with their own code to do the same thing, they have not infringed my copyright just because their program does the same thing. They actually have to have the code that's overlapping. It is possible to also copyright sort of the form and format of your software. So if you have user interfaces that you think are particularly interesting and unique and you don't want people knocking them off, you can copyright sort of the layout. There were cases long ago, between Apple and Microsoft about menus and how they set up their menu bars and all those things. It is possible to copyright sort of the appearance of the software, the interface, so that kind of gives you protection two ways. One, if they steal your code. Two, even if they use different code, if they create sort of the same appearing product, a product with the same appearance, you have some level of protection there too, yeah.
What about the argument with regards to copyrights and patents about they're only as valuable as your ability to enforce them? And for startups especially, you can claim that you're going to be as big as you want to be, but especially if you're trying to spend $10,000 or $15,000 now, just assuming an attorney's not going to take a case on contingency to defend a patent.
Depends on the money. It always depends on the money involved, right? If you have a patent and Microsoft knocks you off and infringes your patent, then I can guarantee you will find lawyers that will take that case and do it on a contingency. But yes, to a certain extent, you know, you can have a patent, but there are no patent police. There's no one that's going to show up at the door of an infringer and make them stop without going through litigation first. So that is a difficulty that some face. However, you know, there are a lot of startups and and companies that aren't startups that amass an IP portfolio, and even if they have never pursued anyone, there may still be a value in there. You know, you have a lot of companies that amass huge portfolios of patents and then pursue people, and so Acacia, Rival Star, and there's some others. There are IP auctions like ones run by Ocean Tomo in Chicago and some others. So there is value to it, even if you can't afford to fight litigation with somebody else, because you know I think there are a lot of venture capitalists that are looking at how you're protecting, you know, whatever your business idea is. Are you doing what it takes to protect it and basically ensure that that value is going to stay there if you do become big? So there is some value there, but you're right. You know, if you're a little guy and somebody with much more money infringes your patent and there's not a whole lot of money at stake, it may be hard for you to find someone to pursue them. But one last thing I'll say on that is that just because you don't pursue them at this instant doesn't mean that you can't pursue them, let's say, 3 years later. So you know, it's not like something where, at least with patents and copyrights, sitting on your rights doesn't necessarily cost you those rights.
Is there a statute? I mean,
There's a 6-year statute of limitations in copyrights, statute of limitations on damages, so it doesn't necessarily preclude you from bringing the action later, but you can only go back 6 years for damages. Copyright law is a 3-year statute of limitations once you know or should have known. So
3 or 30?
3. So copyrights, you have a smaller window in terms of once you find an infringer in order to sue them.
Is that once you find or once they do?
Once you know or should have known of their infringement, that's when it starts.
And then what would you do to make sure that you were within the 3 years? You start litigation or something? Or
Yes, you have to start. So the statute of limitations means that you have to file an action in court within 3 years in the context of copyrights, within 3 years of knowing or when you should have known in order to pursue them. You know, you find out about them, and 6 years later you hire a lawyer and have them sue. As soon as they find out that you have known, that you knew about it for longer, then you may be out of luck. There are some, of course, like everything in the law, there are some twists and caveats on that, but that, generally speaking, that's the idea.
Is there any requirement with regards to patent law to perform? I mean, can I patent, I'm going to make the sky green and I don't have to do anything?
No.
But if somewhere down the road somebody makes the sky green,
you have to. It doesn't work on abstract ideas. It has to be something where you can explain how one of ordinary skill in the art, someone in the field, would be able to practice your invention. So if I come up with some new microprocessor that does X, Y, and Z, I personally don't have the ability to build it, but I could send it to China or to somewhere, and it can be built based on my description. That's good enough. So you just simply saying that it'd be cool to have the sky green, and if somebody's able to do that a few years later, there's no patent there unless you can explain how to do it. Now, if you got an idea on how to do it, then
I don't want to talk about it.
yeah, you probably shouldn't disclose it. Remember, no disclosure. So, yeah.
So I have a website on the bottom. You put all rights reserved. You put a date. Should it be the current date? I mean, should it be the current year? Like, should it be 2014 or should it be 07 when it's built it or whatever?
Doesn't matter. The copyright notices are not necessary to pursue anybody, and the date, the all rights reserved stuff, not necessary for purposes of litigation. So, I mean, I would say whenever whenever you updated it most recently, you may want to put that date on it. I think people frequently, updates that sort of thing every year, and so most websites you go to are going to have the date, that particular year because they've made some updates.
So it's better to have a date in the past than it is.
I don't think it matters.
So maybe it's better to just say since.
That's
2007.
That's fine. And like I said, it doesn't matter one way or the other. For purposes of suing somebody on copyrights, it
As long
doesn't
as
matter
you
what
prove that it's in
date.
the archive or something.
As long as you've registered it, that's all you got to do.
So does this include the name of your company, or is that different?
That's trademarks, which is actually where we're going. Though it's taking me. No, it's fine. I mean, I'm happy. I mean, I'm I'm here to try to give you guys the information that's most useful for you, so.
Okay, I have
yes,
one more
ma'am.
question
Okay,
then. Since you're okay with this.
but we will get to trademarks, so
Okay.
that's it, okay.
So, normally, if you just send a cease and desist to
Mhm.
somebody, is that enough? Normally,
Enough for what?
for them to stop your copyright infringement? Their copyright.
Depends on who you send it to and how concerned they are about it. You sending a cease and desist letter is good in the sense that you're letting them know of your rights, and if they continue to do it, then they could be deemed willful if they are actually infringing. It's bad in the sense that now they know, there is a specific date on which you had knowledge of them, and if you choose to sit and do nothing while they continue to infringe, then you have a statute of limitations problem and a definitive time for that. So, and now with trademarks, it's different. Trademarks, it's more of a problem I'll get to on the trademark side. So trade secrets, just briefly, this is basically information that you keep secret. It's protected as long as you keep it secret. The Coke formula is still a trade secret, even though it's been around for 100 years or whatever it is. Basically, you make an election between whether you want to keep some information as a trade secret or patent it, and those are sort of two very different ways of protecting your information. Trade secrets are, you think of that a lot with non-disclosure agreements and that sort of thing. You have certain trade secrets that maybe aren't patentable, but they are valuable to you. Your client lists, certain processes you use, how you manage the flow of information within your business, how you compensation structures, all kinds of things can be trade secrets. Basically, the definition is anything that's secret or not easily discoverable, and it derives value based on that. So the fact that other people don't know it and can't easily figure it out is why it's valuable. That's what makes it a trade secret.
So there seems like it'd almost be like a closed source.
There's no registration. Most of the time when you're dealing with trade secrets, you're dealing with employees that leave, and you have to pursue them because they've taken your information with you. That's what. So trademarks. Trademarks, that really covers a lot of different things. It covers words, logos, slogans. It can cover sounds. It can cover colors. It can cover product configuration to a certain extent. Typically, that's referred to as trade dress, but trade dress is a type of trademark, essentially. A trademark is how you distinguish your goods or services from others, and a trademark really covers both goods and services. Service mark, sometimes you will see an SM after some like Massey for the pest control. That's a service mark. That name is designating services that they offer for you. McDonald's really is a service mark. They offer restaurant services. Though they probably have some product. They sell a lot of products that are branded that way too. So you can have marks that cover multiple things. For trademarks, you have sort of different types of rights. There are common law rights, which is just within your area where you're offering your goods or services. You have those rights based on people's knowledge of your name, of your brand, of your trademark. You can register at the state level. For example, you can do Florida registration. I want to say it's $87.50 or something, $87.50 or something like that to file it at the state level, and then but that provides you with rights within the state that you're in. So in our case, Florida, and then federal. That's where you file with the U.S. Patent and Trademark Office. The filing fee, I think, is $325 per mark per class. So trademarks and service marks go to specific products or services that you're offering, and those fall within specific what are referred to as international classes. So if you offer cosmetics, that might be one class, but if you also offer baseball caps, that's another class, and if you're also selling software, it's another class, and if you happen to also have restaurant services, there's another class. So for every mark that you want to register for each type of goods or services, you have to get a separate registration and pay for a separate registration from the Patent and Trademark Office. And the,
Is there a disadvantage to doing federal versus state? I mean, is
No,
it
it's the other way
bigger
around.
umbrella?
federal is, I think federal is far better than state. Federal gives you rights nationwide regardless of whether you've used it elsewhere. So if you're, I mean, to qualify, you have to be engaged in interstate commerce, but that's a pretty low standard. And so, you know, for example, with common law rights, you really can only expand your rights to where you offer your services and a sort of a zone around that, the zone of natural expansion. But federal rights, you know, even if you're selling in Florida and Alabama, you know, if there's someone, if you have a federal registration, someone in Washington starts to use your mark, you know, you may be able to sue them, even though you've never sold anything to Washington, and you may never sell anything to Washington because you have federal rights, and that extends across the whole country.
So the only advantage to the state is that it's cheaper.
Yes, the state is cheaper. I don't think there's a whole lot of value in it, but some people like to have them also. I know you had a hand up, and then I know you did too. Go ahead.
So I had a name of a company, PR company here in Florida,
Okay.
and I had an internet site. And then someone in California got the same name and had an internet site. I don't do business outside of Florida,
Okay.
but being the internet, when you search, you're gonna find her instead of me.
Okay.
So how does that work?
Well, I assume you didn't have a you don't have a registration, and that makes
I just had a business.
right.
for-
Yeah. So registering your name with the state, you know, Bob's Plumbing or whatever, when you file your corporate, you know, Bob's Plumbing Inc. That is not a trademark registration. That's just how you have identified yourself to the state for purposes of your name. And likewise, doing a search on Sunbiz for other people that have the same business name doesn't necessarily mean that you are free to use whatever that market is. You know, the rights are associated with the products you're offering, and who, you know, and the distinctiveness among your consumers. And so without a registration, if you are sharing you have the same mark in Florida as someone in California, unless you acquire a federal registration or somehow we're selling into California and have rights there, you're probably not going to get very far on that. Yeah.
In lots of different classes and trainings and things we're talking about IP, the protection of it. One of the things I always saw that was overlooked was we've never really gotten into is the significant part of protecting your IP is especially if you're going to have a raised capital. So if you haven't reverse engineered your business concept from X point in time out, and you aren't perceiving that you might actually need capital at some point in time, you're in trouble. So you might as well just go federal all the time, in my opinion.
Yeah, no, I agree with you, and you know, I mean, I'm happy, you know, if somebody feels like they want the state. I mean, sometimes you may get the state registration if you think there's going to be a problem with the Fed trying to get the federal registration. Now you're using it in Florida and someone else is using it elsewhere. You don't know if you can beat their date, and so rather than filing federal, also if you only offer your services in Orlando, if you're Orlando Plumbers, which is a terrible mark, but that's an easy one for me to say. If you're Orlando Plumbing and you never offer any products or services outside of the state of Florida, you're really not going to be eligible for a federal registration anyway. So anybody that's able to do it, it makes the most sense, even though it's a little more money. Yeah.
If you register your stylized name
Yep.
and includes the name, if the previous name is abandoned, does registering the stylized name cover you on the name itself as well?
Well, it gets more complicated. You can register it in multiple forms. So in the broadest sense, you can register it as just plain text, and that means that, you know, if I have Bob's Plumbing in plain text, then whether you were using Bob's Plumbing in Arial font or in bubble font or with some other logo along with it, that may not save you. So in other words, that plain text is the broadest envelope that you can get now. You know, sometimes that may not be available, whether someone else is using something similar, or whether it's too descriptive and you need to add something to it. And so it could be the notion of stylized text. It could be incorporating it with a logo, something like that, to try to sort of get you to the point where it's going to be something that you can register with the patent office.
But if the name doesn't exist, you
If
go
nobody
broader.
else is, if nobody else is using the name and it's distinctive, it's not descriptive of your services, then yeah, that makes the most sense is to go with it. And if you have a logo that you like to use also, and a lot of people will do the plain text, and then when they can, they'll do the logo. Because one of the things, I know you have your hand up. One of the things that just like copyrights, your trademark rights begin as soon as you start offering your products or services. So your trademark rights begin, the day you open shop and start offering your products or services to customers. But there are advantages to getting to the patent office early. But if you have to prioritize your money, I mentioned earlier, patents, once you start disclosing it, you risk losing them, and there's also the first to file rule. Patents, in terms of if you have multiple types of IP, you want, I would say patents should be the priority in terms of getting that first. It's the biggest allocation of money, but it's also the only one that you can't recover later. You can always, down the road, you can register your copyright. Down the road, you can register your mark, assuming someone else hasn't already taken it. But the patent will be gone once it's been disclosed for a certain period of time, or if someone beats you there. So yeah.
You are, I guess I normally hear of, say, different companies protecting or litigating their trademark or their patents and things like that, but it seems like it's always the big company against the little guy, trying to exert their efforts. What about if it's, a one-on-one or two small businesses that are in conflict there? Could you go through just very briefly the process that you would go through to litigate your mark or your patent?
Sure.
And what is the likelihood of being successful?
Well, I don't know if I can give you a likelihood of being successful just because it's so fact dependent, but I can tell you that whether it's two little guys, two big guys, or big and little, it's the same process. It's really just a question of sort of scale and the money that's involved, depending on whether you're dealing with a mom and pop shop that has 3 boxes of documents and 2 people that you have to talk to, or Apple, and you've got servers full of documents that have to be searched, and you have 47 people that need to be interviewed, and so it's really just sort of a scalability. In terms of the process, it's pretty straightforward. You can start by trying. There are a lot of people send out cease and desist letters. If you're aggressive in trying to police your mark, which is something that you should do if you want to protect your rights to it, because unlike patents and copyrights, trademarks, if you sit on your rights, you lose them. So if you know that there are 10 other people that have started using a mark like yours, eventually it can be deemed that you have abandoned your mark because you've failed to pursue others. So you may start with a cease and desist letter. That provides somebody notice, and sometimes you're able to work it out. They're able to say, hey, I was using this mark 10 years ago. Did you realize that? Or, oh, I just adopted this. I didn't know you were there, and so we'll stop. It could be something more in the middle. It could be, we've been using this mark for several years also, and what you're asking us to do would cost us money to, change our signage and change our menus and whatever. And so there may be some possibility of trying to resolve it that way. But otherwise, if you can't resolve it just informally, then you file a suit. For trademarks, you can file it in state or federal court. I always go to federal court. I think it's a much better option, but it's also more expensive on the front end. In terms of the federal court, number one, requires you to do lots more at the beginning, and number two, they're much more rigid about their deadlines, and so you can't sort of push things off because you're having problems getting things done like you kind of can in state court. So, and then once you do that, it's just litigation until either a judge decides who's right or wrong, or a jury decides it. And I mean, of course, there are appeals too, but that's basically the process.
Looking at the defensive side, somebody was asking me the other day, how do I determine what's the best kind of a trust to use? And I'm going to use this as an analogy. I said, not so much about that in my book. It really is about what's the record of the company that's going to defend the trust. Wouldn't that be kind of applied to this as well?
It does to a certain extent. I mean, there's so sort of IP registrations, the focus is as I mentioned up there, is negative rights. And what I mean by that is that when I have a patent, what that really tells me is that I'm the exclusive person. I own the exclusive rights to that. It doesn't actually, most people won't realize this, but a patent doesn't actually give you the right to practice your own invention. But it says that you can keep others from practicing that invention. Similarly, with the copyright registration, in that case, you can continue to sell your copyrighted work, your song or whatever. But if someone else tries to sell it, you can go after them and stop them. Trademarks, you know, it's great to have brand value and build up the value in it, but really a trademark registration doesn't do anything for you other than give you more tools to pursue someone else. And so most of the time, you're thinking kind of in the context of offensive use of them, but you do have to consider defensive use too, namely, how do I keep my business from getting sued by someone else who, you know, and so to a certain extent, yes, it depends. You know, if you get cease and desist letters from somebody, the first thing you do, one of the first things you do is look up their rights and maybe do a search on whether they've sued people, because I mean, we represent some companies that have sued lots and lots and lots of people, because every time somebody uses their name, they go after them. You know, the whole goal is to basically shut them down and keep that usage exclusive. And some people are much more likely to pursue infringers than others. So, you know, you never know what the other side's going to do, but that at least gives you a hint to it. Yeah.
You talked about trademark searches, and you know, just because we've looked into that, there's obviously a lot of costs with that for startups as well. But you also talked about the idea of somebody been using the name for years. Like if Phil had been using their company's name for a while, but hadn't trademarked it federally, and I went and federally trademarked it, how does that work? Can I send him a letter and say stop using your name?
You can send him a letter. I don't know that you'd be very successful in it. So the answer to that question is, so it is possible, you know, when you go to select your mark, it's possible to do your own searches, but there are, you know, lawyers for the most part are going to have access to databases that other folks don't, just because we pay subscriptions for various databases. If you have a mark, it's possible to do a full US search where you're searching both nationwide registrations, which is something that you can look for to a certain extent, but also state registrations, and you can actually look for common law too through things like Google and some other options. And so you can go to law firm ours or another and get patents, what are referred to as clearance searches. They do it, you know, we can do it for patents, we can do it for trademarks, not really on copyrights. The tricky part with trademarks is that it doesn't have to be the same mark. You know, Show Flow and Show Pro, they're not the same mark, and if you looked for Show Flow, you won't ever find Show Pro, because it's not the same. You know, it's not the same
What if it has
mark.
like an exclamation point?
And now punctuation isn't going to make any difference, but you know, changes in spelling can make a difference. It's something where you might not find it because someone else is spelling it slightly differently, but through some of the fuzzy searches that we can do, we may be able to find some more of those. And once you find those, then there's a question of whether it's close enough, what the registration specifically for, what the two industries are, and sort of that's where it gets into you know, a lot more judgment involved in how close the products are, likelihood of confusion. Because ultimately, for a trademark, the question is whether consumers are likely to be confused between the products. I mean, I always think back to it starts to date me, but for people that have seen Coming to America, and if you remember, you know, they had McDowell's, yes, and the golden arcs instead of the golden arches, and they had it was very similar, and the question is, you know, is a consumer likely to confuse those two? And of course, the answer is yes. In that, there's no doubt that a consumer would confuse those. But you know, if you have two companies using the same name, I was involved in a case where we represented a boat company, and they used the name Daytona on their boats, and we were in litigation with the Speedway. You know, and then the question, and we prevailed in the first round of that. The question was, is someone who, you know, watches NASCAR at the Speedway going to be confused and believe that these $150,000 boats that also say Daytona on the side are somehow associated with the Speedway? And you know, the court found that they wouldn't. So you know, so it is possible, even with the same name, that there's no confusion. It's possible with different names that there could be confusion. McDowell's, there's going to be confusion.
Mhm.
So there's a lot of judgment called to it, and part of the what you look at is the strength of the mark, and that's really gauged based on kind of the distinctiveness of the mark. And the courts use kind of a scale that it's referred to down at the bottom here. I have fanciful, arbitrary, suggestive, and then descriptive is the last one that's not available. Here's an example of some arbitrary or fanciful marks, either words that don't mean anything like Exxon, Xerox, Polaroid, Marlboro. Actually, none of these mean anything. I forgot that I had these are all made up words. All of these are made up. If they become associated with your business, those are going to provide a very strong mark for you, because there's no reason for someone else to sell, Kodak paper or Kodak, hats, unless they want to be associated with Kodak.
I think for us, the main point here is the internet. So if I get Exxon.com, what does that mean?
It means that they're going to sue you. Yeah, there's
So if
there's
this
a
girl in California has my name as her internet site,
well, it's 15 USC 1125D. I'll give you that again. 15 USC United States Code 1125D. That's the statute for cyber piracy, and that's the question of whether using someone else's mark, I believe it has to be registered in a domain name, causes confusion and is considered cyber piracy. So again, it comes back to needing a registration. It also comes back to there are some other factors that get not confusing but difficult, like whether there's bad faith involved, whether they picked it. If you adopt Exxon.com or Coca-Cola.com, I mean, there was a whole string of those early on with the
early
internet.
on, everybody was
Yes.
buying Coke.com.
Right, and the law would come down on most of the time it was more expensive to pursue them than to just pay them some money and make them go away. But at the end of the day, the law says that you can't do that, and if they pursue them all the way to the end, they would probably be successful. And I think they were.
Does that stand for squatters as well?
Yeah, it's
You are
cyber squatting,
cyber squat.
it's a cyber squatting, cyber piracy statute.
Okay.
And it's also, it also deals with typo squatting. I don't know if that's the right one, but yeah, where you change.
EXON.
Exactly.
Two X's.
Arbitrary. These are words that have a meaning, but they don't have anything to do with the product. Apple obviously doesn't have anything to do with computer. Well, it does now because it's the most powerful brand in the world, but when they adopted it, it didn't have anything to do with computers. Target, Camel, Nike, all of these are unrelated, and so these are strong as well. Suggestive is sort of a notch down. Obviously, something like Coppertone, you're suggesting tan. Verbatim for discs. 7-Eleven. I mean, these are all words that suggest something about the business, but they don't really tell you much about it. Generally, descriptive words can't be marks. It is possible that after a certain amount of time, typically 5 years, you can try to prove to the patent office that you have acquired distinctiveness. But Bob's Plumbing, Orlando Fitness, these types of things that describe what your business does. And I looked at all the startups this round, and I didn't see anybody that I thought really had this problem. The closest one was Flight Fisher.
He's not here today, but yeah.
Okay, yeah, that's
He's
the
being sued
closest.
right now.
But that one's that one
Can we
is
sue?
it's probably
Only if we grab it first.
that one's probably considered suggestive. It's probably not descriptive, but it's closer. Everybody else was far enough away.
So are you saying that Avis can advertise themselves as Avis, but not Avis Car Rental?
No, I'm saying that Avis Car Rental is fine, Avis is fine, but if they had just named themselves Car Rental, that wouldn't be okay, because even with National Car Rental, which was the example I had before, It's not it wasn't distinctive originally. Now, given the amount of marketing dollars and time in the industry and stuff, it's become distinctive now. And if you had a name like that, you would always use your logo to try to acquire that distinctiveness. So, you know, you probably know National's mark or Avis's mark, the logos. You know, those provide some level of distinctiveness. But the point is that to the extent that you're either picking your company name or the name for whatever your product is, you're better, you know, you want to stay away from things that describe it. Generic terms can't be trademarks. So, you know, there are a lot of marks that have become generic over time. Aspirin, Kleenex is not, but Kleenex is one that's sort of borderline. Xerox was getting there, and they maybe have done enough to try to keep it from becoming generic. Escalator was a trademark at one point in time. So
How long's
the
a
idea
trademark
is,
last?
what?
How long's a trademark last?
Trademark, you can renew it every 10 years for as long as you're using it. So, but you have to enforce it and protect it. We talked some about acquiring trademark rights. And basically, you get the rights as soon as you start using it. The registration is the more important. You know, is important for making sure that you, number one, you put other people on notice by acquiring that registration, and number two, as soon as you get the registration, that registration gives you more ability to enforce your mark. There is a process where you have to deal with the trademark examiner through the trademark office. Kind of like patents, probably not quite as vigorous, but you will have to, you know, the trademark examiner will look at it, will decide whether your mark, whether that examiner believes your mark is sufficiently distinctive to be registered. You do have to do, like I mentioned earlier, you do have to do it for specific goods and services that you use.
Would you mind going back one speech? The one before that?
This one?
No, but before that.
That one, the generic.
Thank you.
The benefits of registration, you get a presumption of validity with it, which means that when you sue somebody, it's presumed to be a valid mark, you're presumed to have rights in it, which is good from your perspective. Like I mentioned before, it gives other people notice. For federal registration, it gives you larger scope of rights than you might otherwise have. And you get the right to use Circle R. If you have a Circle R behind your name or your brand and you do not have a U.S. registration, you need to take it off because it's not